Starting November 1, 2025, major changes will officially take effect for green card applicants, visa holders, and sponsors, and these are not just rumors or proposals anymore. The U.S. government has finalized several updates that will directly impact how applications are processed, who qualifies for sponsorship, and how long approvals may take. These new immigration measures are part of an ongoing effort to tighten oversight, reduce fraud, and make the system more consistent, but for thousands of families and applicants, they also bring new challenges and responsibilities that cannot be ignored. Under the updated rules, green card and visa applicants must now attend their interviews in the country where they legally reside or hold nationality. This is a big shift from previous years, when many applicants could choose to interview at other U.S. embassies or consulates with shorter wait times. For example, someone living in Asia but originally from another region could previously apply to have their interview elsewhere to speed things up. Starting this November, that flexibility ends. The U.S. Department of State says the change will improve fairness and national security, but it also means longer queues and fewer options for applicants stuck in high-demand locations. In addition, new verification standards are being introduced for sponsors, especially those supporting family-based immigration cases. The government will now require stricter proof of income, financial stability, and relationship authenticity before a petition is approved. Sponsors who cannot meet updated income thresholds or who fail to provide detailed financial documentation may see their applications delayed or denied altogether. USCIS has also confirmed it will take a tougher stance on incomplete submissions, meaning applications with missing forms or outdated information could now be rejected without warning or a chance to correct them. These changes mark one of the most significant updates to U.S. immigration policy in recent years, and they will affect everyone from families waiting to reunite, to workers applying for employment visas, to sponsors trying to help loved ones start a new life in America. Stay tuned, because in this video, we'll break down exactly what the new rules mean, who's affected, and how you can prepare before November 1 arrives. And before we get started, don't forget to like this video. It really helps more people stay informed about these crucial updates that could change their immigration future. The new immigration rules taking effect on November 1, 2025 are not minor adjustments. They represent a clear signal that U.S. immigration authorities are entering a new era of tighter enforcement, increased scrutiny, and modernized verification systems. For many applicants, this means that the process of obtaining a visa or green card will look very different and potentially more challenging than it did just a year ago. The U.S. Department of State and U.S. Citizenship and Immigration Services, or USCIS, have both confirmed that these changes are part of a broader plan to make the system more transparent and efficient. But behind that official language lies a deeper story, one about accountability, backlogs, and the government's push to regain control of a system that has been stretched thin for years. Let's start with what's likely the biggest headline from this policy shift: the new interview location rule. Under this rule, every immigrant visa applicant will now be required to attend their interview in the country where they are either a citizen or a legal resident. This means that the long-standing practice of third country processing, where people could travel to another embassy or consulate with shorter waiting times, will officially end. For years, this workaround helped applicants escape huge backlogs in countries with heavy visa demand. A person living temporarily in another country could request an interview there, and often get it scheduled faster. But beginning November 1, that flexibility disappears completely. The Department of State argues that this change is about consistency and fairness. They want to ensure that interviews are conducted where the applicant has established residence, and that consular officers have access to all the proper local documentation and background checks. However, immigration experts warn that the consequences could be significant. In places like India, the Philippines, Mexico, and Nigeria, where visa wait times already stretch over a year, this could make the delays even worse. Families who were hoping to reunite sooner may find themselves stuck waiting longer simply because they can no longer transfer their cases elsewhere. Now, if you think this only affects people applying from abroad, think again. The ripple effects will reach those inside the U.S. too, especially sponsors. When you file to bring a family member or loved one to the United States, your case goes through several steps, and one of them is the interview scheduling at a U.S. embassy or consulate overseas. With the new restrictions, sponsors will have less flexibility in choosing interview locations for their relatives. This could slow down cases that might otherwise have been approved faster. And here's where things get more complicated. Alongside the interview rule, the US government is also tightening its sponsorship verification process. This means if you're sponsoring a spouse, parent, sibling, or child, your financial information will now be reviewed with greater scrutiny. Sponsors have always been required to prove that they earn enough to support the immigrant financially, typically through an affidavit of support form. But under the new policy, USCIS officers will verify not only your income but also your tax compliance, employment stability, and in some cases, your assets and debts. The reason? U.S. immigration officials want to minimize situations where new immigrants become financially dependent on public assistance soon after arriving. The policy's goal is to ensure that sponsors are financially capable and committed to their responsibility. That may sound reasonable, but the reality is that it could make life harder for families who are still recovering from inflation, job instability, or post-pandemic economic struggles. Consider this example. Let's say Maria, a U.S. citizen, is sponsoring her elderly mother from the Philippines. In the past, she could submit her most recent tax return, a few pay stubs, and an employment letter to prove eligibility. Under the new rules, the reviewing officer can now request additional evidence such as bank statements, credit records, or proof that her job is permanent and stable. If Maria has recently changed jobs or had a gap in her employment history, her case could be delayed or even denied until further proof is provided. This increased scrutiny doesn't stop at financials. USCIS has also expanded its ability to deny applications outright if they're incomplete or submitted with outdated forms. Previously, applicants who made small mistakes often received a request for evidence, which allowed them to fix errors without losing their place in line. But as of 2025, that safety net is shrinking. Officers now have broader discretion to reject applications that are missing documents, signatures, or current versions of required forms without warning. It's a change that might sound small, but for applicants, it's massive. It means that precision is more important than ever. Every line, every document, every signature counts. Immigration lawyers are already advising applicants to triple-check their submissions and ensure that they're using the latest USCIS forms available on the agency's website. A single outdated page could result in months of delay or even a full case rejection. Now, let's talk about why this is happening now. For years, the U.S. immigration system has faced mounting pressure from record-breaking backlogs to concerns over fraud, fake sponsorships, and incomplete documentation. After the pandemic, consulates around the world were struggling to catch up on interviews that were postponed for months, even years. This created a massive logjam. To regain control, the Department of State decided that standardizing interview locations and tightening verification processes could help restore order. In theory, these rules could streamline operations over the long term. But in the short term, they're likely to slow things down even further. For example, in countries where the local U.S. Embassy already handles thousands of cases every month, the sudden influx of additional applicants who can no longer go elsewhere could overwhelm staff capacity. We might see longer appointment backlogs, especially in regions like South Asia, Latin America, and Africa, areas that already experience some of the highest demand for U.S. visas. This brings us to another important aspect of the November rule changes: security checks and digital verification. The new system will incorporate updated technology that connects consular posts more closely with USCIS and the Department of Homeland Security. This integration allows real-time sharing of applicant data, financial records, and case histories. While the goal is to reduce fraud and speed up legitimate approvals, it also means that small inconsistencies, even accidental ones, could raise red flags faster than before. For instance, if the income figure you list on your sponsorship form doesn't exactly match your tax return or your employer verification letter, the system could automatically flag your case for review. That doesn't mean automatic denial, but it does mean delay, possibly several months of additional processing while officers manually verify your information. In this new era, accuracy and consistency are your best friends. And it's not just individuals feeling the impact. Employers and work visa sponsors are also being affected. Businesses that hire foreign workers through programs like H-1B or L-1 visas must now provide more extensive documentation proving that their job offers are legitimate and meet wage standards. The Department of Labor and USCIS have both issued notices warning employers about stricter compliance checks. This includes verifying that salaries meet the prevailing wage level for each role, and that sponsored workers will perform duties matching the job description filed in the petition. Any mismatch could lead to a denial or audit. What's especially challenging for businesses is that these audits can now be triggered electronically. The new data sharing system connects multiple federal databases, making it easier for authorities to cross-check payroll records, tax filings, and corporate registration details. For large companies, this might be just another compliance hurdle. But for small businesses or startups that rely on skilled international workers, the additional scrutiny could be overwhelming. Another key aspect of the November reforms involves family reunification cases. These are among the most emotionally charged applications in the system, as they determine how quickly loved ones can be reunited after years of separation. Under the new policy framework, priority will continue to be given to immediate relatives of U.S. citizens such as spouses, parents, and unmarried children under 21. However, extended family categories, like siblings and adult children, may experience even longer waiting times as consular posts handle the influx of applications confined to local jurisdictions. For many families, this will feel like a setback. People who have already been waiting 5, 10, or even 15 years for their turn might now face further delays simply because they can't transfer their case to a less crowded consulate. Immigration attorneys suggest that anyone in this situation should start preparing now by ensuring that all documents are updated, valid, and ready to go as soon as their number becomes current. Now, let's address what sponsors should do right now to prepare for November 1 St. The most important thing is to review your financial readiness. Check your income levels against the federal poverty guidelines for your household size and make sure you're above the minimum required by USCIS. If you recently changed jobs or your income fluctuates, consider adding a joint sponsor, someone who meets the income requirement and can help strengthen your case. Also, make sure all your tax returns are up to date and accurately filed. Remember, the new system will cross-check your data, and inconsistencies could cause delays. Applicants should also pay close attention to timelines. If your case is currently being processed and you think you might be affected by the new interview rule, reach out to the National Visa Center or your immigration attorney for clarification. In some cases, interviews scheduled before November 1 might still follow the old rules, but anything scheduled after that date will follow the new system strictly. Missing or postponing your interview could push you into the new process, which might come with longer wait times. Another critical point concerns communication with USCIS. With the agency's expanded authority to deny incomplete applications outright, you can't afford to overlook any part of your paperwork. Double-check your forms, signatures, translations, and supporting documents. It's no longer safe to assume you'll get a request for evidence as a second chance. Immigration professionals recommend keeping digital copies of everything you submit, along with delivery confirmations, in case you ever need to prove that your submission was complete. For those applying for green cards from inside the United States through adjustment of status, the good news is that these applicants won't be directly affected by the new consular interview rule. However, they could still experience processing delays if USCIS offices prioritize other cases under the new digital coordination system. The agency has already begun rolling out software that integrates data with the State Department, and while this may improve efficiency later, there will almost certainly be growing pains at the beginning. It's also worth noting that immigration policy changes often have unintended ripple effects. For instance, a rule meant to streamline consular processing could end up clogging domestic application systems as people try to adjust their strategies. Attorneys across the U.S. are expecting an uptick in adjustment of status filings as applicants who can qualify for it decide to avoid overseas processing altogether. This could increase wait times domestically, especially for employment-based categories. Looking at the bigger picture, these November 1 rule changes reflect a broader pattern in U.S. immigration policy over the past decade. Each administration, regardless of political party, has aimed to balance national security with family unity and economic opportunity. But as global migration increases and technology improves, the government's ability to detect fraud and enforce compliance also grows. That's why we're seeing stricter verification, centralized interviews, and tougher documentation rules. For those navigating this complex system, the most important thing is to stay informed and proactive. Don't rely on outdated advice or assumptions from old cases. Immigration policies evolve constantly, and what was true in 2023 or 2024 may not apply in 2025. Official government websites like USCIS.gov and Travel.State.Gov regularly post updates, and reputable immigration attorneys often publish guidance within days of new announcements. To sum up, the upcoming November 1 Stone, 2025 changes will reshape how thousands of immigrants and sponsors interact with the U.S. immigration system. The end of third country processing, tougher sponsorship standards, stricter document verification, and enhanced digital security checks all signal a shift toward tighter control and precision. For applicants, this means more preparation, more patience, and less room for error. But with careful planning, accurate documentation, and timely submission, success is still very achievable. This isn't the time to panic, it's the time to prepare. Because whether you're sponsoring a loved one, applying for a work visa, or waiting for your green card, the decisions you make now will determine how smoothly your journey goes once the new rules take effect. So keep watching, because up next, we'll walk through exactly how to strengthen your case before these changes roll in and how to avoid the most common mistakes that could get your application rejected under the new rules. And before we continue, don't forget to like this video. It helps spread awareness to others who might not yet know what's coming on November 1 Stone, 2025. The more informed we all are, the better prepared we'll be to face these changes together.